This video is provided for general educational purposes only and is not intended as legal, tax, or professional advice. Real estate laws, forms, and practices vary by state and can change over time. Always read documents carefully before signing and consult appropriate licensed professionals. Welcome to the Blueprint of Trust, a seller and lease owner's guide to property disclosures. This video will walk you through the essentials of transparency in property transactions. Non-disclosure is the leading cause of post-sale litigation, making it the #1 real estate lawsuit. Withholding material defects can be treated as fraud, potentially canceling the sale or leading to legal liability. The golden rule of real estate is, when in doubt, disclose. This applies even if the buyer hasn't asked, or if you don't personally consider the information material. A material fact is any property condition that negatively impacts value, affects the buyer's decision, or is necessary to prevent a previous statement from being misleading. If it passes this filter, it must be disclosed. The key instruments of transparency is the Residential Seller's Property Disclosure Statement, or SPDS, and the Residential Lease Owner's Property Disclosure Statement. These forms protect you by systematically documenting what you know. When selling, disclosures are warranties that survive closing and must be delivered in most states within 3 days of contract acceptance. When leasing, existing defects must be disclosed prior to occupancy, though you have no legal obligation to correct defects unless uninhabitable. Ownership and property. This includes legal status, land and zoning information, restrictions like age-restricted communities, and violations or liens, such as tax liens or pending litigation. Building and safety. You must disclose information about the age, leaks, unpermitted contractor work, water pressure, septic systems, termites, and compliance with pool safety barrier requirements. Environment and utilities. This includes the surrounding environment, like air and sound, conditions of the ground and water, and hidden issues such as mold, flooding, or drug labs. The "I don't know" protocol means if you have personal knowledge, answer truthfully and attach documentation. If not, do not guess. Lack of knowledge is acceptable. Guessing creates liability. There are things you do not have to disclose, such as the site of a natural death or homicide, or if the property was occupied by someone with HIV/AIDS. However, intentional misrepresentation is not protected. If a buyer asks directly, you must answer truthfully. The timeline of transparency starts pre-listing by gathering facts. The clock starts at contract acceptance, and there is a mandatory deadline to provide the disclosure. In most states, that deadline is day 3. Also, the seller must provide updates if material changes occur before closing, and disclosures survive closing as warranties. The cost of silence includes being in breach of contract and buyer cancellation, potentially leading to the recovery of the earnest money deposit, and, in severe cases, civil liability for fraud. A proactive seller strategy involves 3 pillars. Pre-inspect to identify and fix defects, document everything by attaching relevant paperwork, and over-communicate to minimize claims of being misled. A heavily documented disclosure statement is a hallmark of an honest, premium listing. To protect yourself and your transaction, disclose all material facts. Understand differing rules for selling versus leasing, never guess, and let the golden rule guide you. When in doubt, disclose.